Yeah, the shirt sounds good.
I have to confess. Yeah, I have to confess that you guys made us work so hard.
Really? Yeah, well, I've done the same.
I had to, I had another hearing, which was a very contentious hearing.
Yeah.
Now I have, the same point. Now I have another post-hearing submission.
Yeah.
And my parents were here for almost a month. And I didn't meet my parents. What I did was I went to Delhi to drop them. You would think I spent 2.5 hours with them.
Well, that's good. You're pretty busy.
It is like not so much, but now on the DXC side it is.
Okay. That's great.
I have a very dear friend. I will talk about him later. One of my very close persons is also there. He's also from Berkeley.
Oh, yes. Okay, in our office. Summit. Yeah, he's doing a lot of good work at the moment. Sanctions and...
I told him once, I said we were supposed to meet. He said, we are on the opposite side. Things going on.
Professionals.
Is everyone ready? Okay.
Yes.
All rise. Good morning all. We are here today for a hearing in the matter of CFI 045-2017, Actina FZCO versus Standard Chartered Bank. The claimant is represented by Emirates Legal, lead counsel Syed Hussain to the right, and the defendant is represented by Simmons & Simmons, lead counsel Fahim Beheshti to the left.
Your Honor, with your permission, there are two important facts which, with your permission, I would like to bring to the attention of the Honorable Court. Last evening at 6:08 p.m., after the close of business, we received a very voluminous submission titled Application for an Immediate Judgment. It was, in this regard, there are two submissions that I need to make. I, of course, did not have an opportunity, considering I was engaged in other things, to review the contents of the immediate judgment. But that's also not and also the other side is not insisting that I should, considering that it was submitted at the last moment. It appears to me that their concern is that until this application for immediate judgment is decided by this court, we should, these proceedings should be stayed or kept in abeyance or postponed for the moment. With regard to the submission, I beg to differ. The reason I would oppose this motion is because I feel there are some very interesting points which this court should take note of before it passes any order. First, Your Honor, the question is whether this application for an immediate judgment can even be discussed in this court. And the second point is, can the court, while framing the timetable, even remotely look at this application? And the reason why the court cannot do so, Your Honor, is because there is a time period mentioned in the rules of the court, RDC. And the time period is, if you want a matter to be heard, in this case, management conference, or you have an application that you want to put forth, you must at least give 7 days notice to the party. Had this application been filed or those submissions submitted before the court 7 days in advance, which was they had time until 23rd of January. In which case, Your Honor, it would have been possible for the claimant to comment on the merits of the submission that they have made. However, it is for this reason I submit before this honorable court that at this stage the court should go ahead with this case management conference and not even look at the impact of their application, because they didn't follow the applicable rules and did not submit it and did not give us an opportunity. Merely submitting it at 6 or 8 p.m., which is outside their business hours, is definitely not a consideration that one should take into account. So at this stage, Your Honor, I want to take your permission, unless my learned counsel wants to say something just now, and then I can go into my reasons for opposing this CMC, because I have made this submission. So is it possible for me to give you 10 reasons why the CMC should not be postponed first, and then give a better opportunity to my learned counsel to oppose, or would you like to?
It might help, because it might save you the trouble for your 10 reasons, if I do say a couple of words, Your Honour.
Please, proceed.
Just first of all, the notice period for the provision of applications, with all due respect to my learned friend, he's got it wrong. Applications that are sought to be heard at the CMC are required to be given within certain timetables. But there's nothing in the rule book that prevents us from having brought an application yesterday or during the course of this CMC or at any other time, provided that the other side is given the opportunity to respond to that application in accordance with the timetable set out for general applications or specific applications like those for immediate judgment. There is no question that we would expect the claimant to have prepared to respond to an immediate judgment application during the course of this CMC. It's just not the case. The timing of the application for immediate judgment could have been later this week. Our client's position is that it was better to get it in at some point, even though it was last night, or it was certainly before 4 p.m. when the application was made to the court. It was better to put it in that time, so that today at least we would not waste the opportunity to discuss a timetable for summary judgment, for the immediate judgment application. That's purely why it was filed at that time, at significant efforts from our side to get it in that time. So whilst I'm sure my learned friend will oppose the application being considered today, it's merely a procedural matter. The application has been brought. I don't think my learned friend, with all the best intentions, could stop that application happening. It's been brought, and that's a prerogative of the defendant to have brought it. It's now a question of how do we proceed from here. We can spend our time discussing the case management conference as if there was no immediate judgment application, but I don't think that's necessary. It might be a waste of time if the summary judgment application is successful. That's all I wish to say. Thank you.
With your permission, Your Honor. Your Honor, there are two important clarifications I would like to make with regard to the submissions of my learned friend. First, my learned friend has very rightly submitted before this honorable court that an application can be brought at any stage of the proceedings, even during the case management conference, and I 100% agree. And I also said in the very beginning of my submission to this honorable court that even if that they are not saying that I should submit my reply today, but one of their main contentions, Your Honor, is, as towards the conclusion of their submission, my learned counsel stated that it will be waste of time to go into the case management conference right now and wait until this application is decided. And he said because there are no reasonable prospects of success. Now, RDC 24.1, RDC 24.2.1a very clearly stipulates that, the submission that my learned counsel made, that you can only make an immediate judgment where there are reasonable prospects of success. I have 10 reasons, Your Honor, simply 10 reasons, and I can count them, and very simple reasons, very logical reasons, as to why this case management conference should not be postponed and must be heard today. May I, with your permission, Your Honor, give you those small, in bullet points, not like a proper, but very in bullet points, give you those 10 points with your permission. Your Honor, if you have our case management bundle with you of the file, I would be shortly drawing attention to para 63, page 114. So if you go to tab 6, if you look at tab 6, and if Your Honor turns to page 114, Your Honor, with your permission, I would like to read the relevant part of paragraph 63 of the submission of the defendant. They say paragraph 3.1 is denied. As explained at paragraph 62 above, the defendant is a bank with its principal office in London. The defendant is not incorporated in the DIFC, as the claimant is seeking to assert. Only DIFC branch is a foreign recognized company, the DIFC. Now, Your Honor, the point I'm relying on. In response to paragraph 3.1 and 3.2, the defendant has acquiesced to the DIFC court's jurisdiction over the claim. This important paragraph I want this court to consider. On one hand, they say, we agree, we confirm that this court has jurisdiction. We agree to submit ourselves unconditionally to the jurisdiction of this honorable court. So if such a submission has been made by the other party cannot, in a second breath, without explaining its reasons, say that we now believe that this case should be concluded immediately on the basis of an immediate judgment. We have given our remarks at page 140 of the tab 7 on this issue. If you go to tab 7, page 140, paragraph 1.6.5. We have made I just want to draw the attention of the court, and the court may review the paragraph in detail. Paragraph 1.6.7, by submitting unconditionally to the jurisdiction of the DIFC courts, the defendant has waived its right to contest the jurisdiction, more so as the case pertains to the breach of regulatory law. Now, Your Honor, I understand that they're not saying that the issue of jurisdiction right now. They're saying that you have no reasonable prospects of success. I am saying, my humble submission is, the reason why, first thing that the court must consider, the first point that the court must consider is that they have agreed to submit to the jurisdiction of the DIFC court, so they cannot say that this court has no jurisdiction. Second, my learned counsel just said that we can move this application at any time. My second reason is, if they intended to file this application for immediate judgment, they first notified us, Your Honor, it's on 18th of January. For the first time, they write a letter to us on 18th of January, Your Honor, and they say that we intend to file for an immediate judgment because you have not filed an application notice in this case, seeking permission of the court to move an amendment. That was the principal reason why we moved an application notice at such short pace. But, Your Honor, why did they wait for 12 days until 29th, or 11 days until 29th of this month before making this application? Because our humble submission is, because they had earlier made a request to us for not having this case management conference, and they wanted to delay the case management conference. So by choosing the 11th hour of the day for making this submission was for us not to have an opportunity to look into the merits of the application, which is exactly what happened, and for the court to take note of that, please don't look into the merits. We have moved this application, so there is an automatic stay of the proceedings of CMC. And I'm giving these 10 reasons that there is no automatic right to stay the CMC, because CMC is the most, in fact, one of the case officers from this honorable court has written a beautiful article explaining the true scope and essence of the CMC. If that article, which is being published on the DIFC website, if is to be understood in its core and essence, then it's only in extraordinary circumstances that this case management conference would be postponed. Third reason is, if the intention of the defendant was for the application to be discussed, I'm not saying for this court to rule on this application, but at least for discussion, Your Honor, then I'm afraid they should have given us at least 7 days' time to go through this application so that at least we are able to put forth before this Honorable Court our submission whether we have reasonable prospects of success. If you see that the basis on which they are making this application is because, as my learned counsel just explained, he said because there are no reasonable grounds. Now I need to demonstrate to this court that there are reasonable grounds, and the only way I could have done so, Your Honor, if this application would have been presented to me 7 days in advance. That unfortunately did not happen. My fourth reason is, Your Honor, that their intent, unfortunately, as I see from a totality of the circumstances as they are unfolding as we speak, it appears that their intent is only to delay the CMC, as defendant does not want this case to go to trial. This case raises very serious allegations of misconduct, giving wrong advice to the claimant relying on that advice and making an investment. Of course, the claimant will not make the mistake of filing a case against such a big bank unless the claimant had a logical ground, Your Honor, to put forth his case before you. So they don't want this trial to start because, Your Honor, my fifth reason, under RDC 24, there must be a real prospect of succeeding. There is no prospect in this case, as I have been saying, because the DIFC court shall always have, Your Honor, jurisdiction to determine the breaches of DIFC laws, which includes the DIFC regulatory law. Now, Your Honor, question arises whether, let us say for the sake of an argument, can two parties enter into a contract in DIFC and say that we exclude the jurisdiction of DIFC courts and we want the jurisdiction of Dubai courts, and that entity is regulated by the DFSA, by the DIFC. Now, if there are regulatory breaches within or outside DIFC, and that entity is, Your Honor, regulated by this authority here, the DIFC courts will exercise compulsory jurisdiction over it. DIFC courts you cannot contract out of the mandatory provisions of the applicable law. Now, Your Honor, I want to explain the whole crux of my case in just a simple example. There is a product sold by Standard Chartered Bank, London. Standard Chartered Bank, London is the parent company. Now, it is operating in the UAE through two ways. One, it has a branch in DIFC, and one, it has a branch in Dubai. But a Standard Chartered Bank, London, UK, is registered in DIFC. It is a parent company that is registered here. It is the entity, it is a central establishment. And the branch is not the incorporated entity because it's a branch. Branch does not have its own separate legal identity. It is an unincorporated entity. Similarly, in Dubai, there is a branch. It's an unincorporated entity. The liability is only of the incorporated entity, which is Standard Chartered Bank, London. Now, from the perspective of UAE law, let's say the judge has to decide this case today. There's only one submission. There's only one point that court will look into. In fact, if we were to shrink this whole case into one small proposition of law, which is this: I have a product in London, and I'm governed by certain regulations in London. And my regulations in London don't allow this product to be sold in London. Now, I bring this product to UAE. I go to DIFC. I can't sell this product in DIFC because there is DIFC regulatory law and this is a high-risk product and it has certain formalities that have to be complied with. But how can, Your Honor, how can the courts of this country allow the same product which is not fit for in DIFC to be sold outside of DIFC? After all, DIFC courts and Dubai courts are Dubai courts. After all, both courts have the right to look into the whole basis and essence of what they're trying to protect the interests of its citizens. Assuming this is allowed, assuming this court were to, I'm not going into the merits of this case, but only to point a very important aspect of why there's a reasonable prospect of success, more than reasonable. In fact, this will be the determinative factor of success in this case, is because you cannot allow an activity that violates the public policy of UAE, because public policy of UAE is you have to treat everyone in UAE alike, whether that person is in DIFC or outside of DIFC. You cannot treat person outside of DIFC in a less protective way than within DIFC, because the regulated entity, the parent company, is after all the Standard Chartered Bank London. So even if this transaction has no link with the DIFC branch, yet it is the liability of the parent company that is responsible. So when you view and the Cornet case, Your Honor, which we have referred to in extensive detail, and Your Honor, that has been followed in so many cases, I don't need to even refer to that case, has settled this issue in absolute certainty. So it is established beyond reasonable doubt that we have a reasonable prospect of success in this case, because you cannot argue that DIFC regulatory law is not DIFC law. DIFC regulatory law is a part of DIFC law. When the courts will look into the violations, Your Honor, in one of the cases which I was arguing before this Honorable Court, a judgment came, and we had not even referred to the DIFC law. The Honorable Judge said, I want you to make a submission on these points of law, which is the applicable law. Now it's also Muhammad Akbar Zia case. And Your Honor, we made a submission, and the judge said, the opposite party said UAE law applies. The judge gave a judgment on the basis of the DIFC law. So even if I would not make an amendment before this Honorable Court and say, I want to include other violations, this court would anyway look into it. But as a counsel, Your Honor, before the court, it is my duty when they say that DIFC regulatory law does not apply. And in my first statement of case, I have not stated, I have not gone into the other aspects of other violations, because it was so clear, the DIFC regulatory law itself was so clear that there was no need to look beyond it. But the fact that they raised it, I had to move an application before this Honorable Court in which I raised those points. So, Your Honor, I established by virtue of this submission, giving you my fifth reason as to why the CMC should not be postponed, this application should not be heard. My sixth reason, which I have just covered, is that DIFC courts are required to exercise compulsory jurisdiction in cases of breaches of DIFC laws, in particular the DIFC contract law. This is not a case, Your Honor, this is the most important point, where the parties, through a contract, can take away the jurisdiction of the DIFC courts. The rationale is that parties can't contract out of the mandatory provisions, Your Honor, of the DIFC law. The determination of breaches by the court of regulatory law does not require parties' consent. Your Honor, I have committed a breach of a regulatory law. Even wherever I run in the world, DIFC courts will catch me, irrespective of, I cannot say I have, through an agreement, excluded the jurisdiction of DIFC courts, assuming that such an argument is raised before this Honorable Court. Although it has not been raised, the point is, there is no freedom to choose in these matters, because these matters pertain to the laws. The seventh reason, Your Honor, is the new application for immediate judgment was filed on the eve of this CMC conference after the close of business, and as I have stated earlier, it can't be even discussed or considered by the court. Now, if it is to be considered, now suppose if it is to be considered, rather not on its merits, but in determining the timetable, Your Honor, or in postponing the conference, then, Your Honor, its impact will have to be examined, because the cut-off date was 23rd January. Now, the reason, my eighth reason is, the reason why the CMC should not be delayed is because the claimant intends to seek an order from this court today. This is our intention, that defendant be directed to produce the testimony of its three principal witnesses, namely Mr. Amin Badamsi, who is the person who dealt with. Throughout my submission, Your Honor, we have stated, the claimant has stated, that he is the one who instigated us. He is the one who corresponded with us. He is the one who told us to do this and what we did. Mr. Asif Ahmed and Mr. Angad Sabarwal. As their testimony will confirm that the claimant was wrongly induced to invest. As claimant does not believe that these witnesses would take the risk of not informing the court, not speaking before this court honestly. Now, Your Honor, assuming that you delay this process, assuming that the CMC is delayed, today is an opportunity for us to discuss this issue. Today is an opportunity for us to discuss, to request the court to pass an order in the CMC so that they will produce the testimony of these 3 witnesses. One, they have agreed, Mr. Amin Padamsi, as I understand, they have agreed to provide the testimony. But with regard to remaining 2 people who we consider as essential witnesses of the case, if this does not happen, Your Honor, we will be denied this opportunity. And my 9th reason, Your Honor, is the reason I derive after reading that article. In fact, what DIFC, that beautiful article written by our case officer says, is that CMC would be most helpful because it tends to bring order and more clarity as dates for filing by the parties and their responses are all set out. So clearly it is in our interest and in their interest to adhere to all the timetables after agreeing to the various things that we have tonight. And lastly, Your Honor, and my 10th and the most important reason is that claimant has a right to know. I am the claimant. I have a right to know their reasons, whether they agree to the amendments which I have proposed or they disagree with the amendments that I have proposed. If the defendant consents unconditionally, Your Honor, then case management conference, in this case management conference, we request the Honorable Court to pass an order and allow the claimant to file an amended statement of case. Now, we need this order, Your Honor, today so that if they agree, subject to their consent, and so that we can submit our amended statement of case, this trial can progress, the timetable can become more effective. Delay today, if this Honorable Court were to delay this hearing today, the delay will deny the claimant of this opportunity, Your Honor. It will not only increase costs, Your Honor, but will also be prejudicial to the interests of the claimant. Your Honor, I just have to one thing I would like to seek the guidance of my learned counsel, considering that these are amicable proceedings here. I have been given to understand that they have no objection to the amendments that we have proposed. If they could clarify that point so I can then address that issue, because that will change a lot of things. With your permission of the court.
Please.
Can I respond to each of my learned friend's points? I'll deal with that one first, if it's helpful. With respect to the amended pleadings, we have many objections to the manner in which the claimant behaved in putting forward the amended particulars, but it's not for the CMC. In fact, our client has now agreed to accept the amended particulars of claim, but it will not accept to be liable for the costs of the application to amend the particulars of claim, and it would also accept the amendments provided that the defendant, as is natural and ordinary, is permitted the opportunity to amend its defence, and in accordance with the rules of the court, that the claimant bears the costs of the defendant amending its claim. Very simply, it's a matter of fairness. The claimant brought a particulars of claim. They called it a statement of case. We had various objections to the way it was presented, but again, we managed to put in a defence and response. They then file a reply, which has, we say, lots of additional claims and causes of action. My learned friend disagrees, but then, surprisingly, if he did disagree, he made an amendment to the particulars of claim. And that's fine. He's within his right to do that. The rules of the DIFC court allow for amendments, but it has to be fair. You can't keep changing your particulars of claim. You have to give the other side the opportunity to respond and not waste their time and costs. And if we are going to have to spend our client's money to amend our defence, it has to be borne by the claimant. There's a very simple principle of court proceedings, which is not to abuse the process. If you are seeking to work outside of the ordinary timetable, one must have to then take responsibility for that in terms of costs. So that's really the simple point on the defence. I don't know if I need to spend too much time on the 10 points, because as I tried to say before my learned friend started on his 10 points, we're not opposing the CMC. We are here taking part in the CMC. This is a CMC. We're not now suggesting it's postponed for anything. A CMC is designed for the parties to agree, as my learned friend said, timetables and how to proceed in the case in an orderly fashion. My learned friend has sought to bring in the merits of the immediate judgment application into a case management conference. That should not happen. We're simply proceeding to establish a timetable for what happens next. Again, there was no intention by bringing the immediate judgment application yesterday other than to allow Your Honour to assist with a timetable for it. In fact, we have no objection in principle to discussing the timetable through to trial. But is that a useful use of our 1 hour when there is an immediate judgment application to deal with? I'm not clear on what my learned friend's point is. Is he saying that we should not have, our immediate judgment application should fail now, in which case, with all due respect, that's absolutely not right. We've brought an application and it's to go through the process under Part 24. If that's what he's saying, we object to it. If he's saying that we should have brought it a long time ago so that at the CMC we could hear the whole thing, that's also wrong. Case management conference is only to deal with issues that have been brought in applications if they were brought in time and suitable for that. Unfortunately, we sought to discuss with the claimant the possibility of postponing the CMC until the immediate judgment application is over, but they didn't want to engage in that discussion. So here we are. But let's make use of this time, we submit, to set a timetable for the immediate judgment application. After that, it's appropriate, if this immediate judgment application fails, after that it's appropriate to talk about a timetable through to trial. It does delay proceedings. It doesn't if we win. If we win, there'll be a resolution of the matter much more quickly than seeing it through to trial. If we lose, it adds, 1 or 2 months to a set of proceedings that, in accordance with my learned friend's case, started about 10 years ago, 9 to 10 years ago. So 1 or 2 months in the grand scheme of things is not going to delay things, particularly if one keeps in mind the overriding objective of dealing with cases fairly and expeditiously. I'll just make very brief comments on the 10 points because I think some of them were, I'd like to set the record straight in terms of what the defendant's position is. To the extent I haven't dealt with him already in what I say. The first point he made was in relation to the jurisdiction of the DIFC courts. I think the point he was making was that if we've submitted to the jurisdiction of the DIFC courts, we cannot seek an immediate judgment. I don't need to say any more than that. I think that's plainly wrong. When you submit to the DIFC courts, you submit to the rules, and the rules provide for immediate judgment, and that's what our clients, the claimants, have sought to do. The second point he made was the first notification of the immediate judgment was 18th of January. The reply was submitted on the 25th of December 2017. That took some time to be considered. There was some confusion from our side as to whether the reply was in the right format because it was not responding to the defence. It was essentially creating new pleadings and new claims and new causes of action. And so there was a debate as to the amendment issue, which I've already addressed you on. The third point was about the theory that the claimant is seeking to delay the CMC. Again, we are at the CMC, we are having the CMC. I admit, with all due respect, that the immediate judgment may delay the grand process, but it may not if we win. And I think that covers the fourth point as well, which was the allegation that there is a conspiracy to delay the hearing. The fifth point was about the test of an immediate judgment application, which is one limb of it, at least, is no real prospect of succeeding. That is a debate for the immediate judgment hearing and process. It's not for the case management conference. It is not. It's simply unfair procedurally to hear the immediate judgment application in part in this haphazard way at a case management conference. There will be a hearing on the immediate judgment application, I expect, and that's the case by all of these points that my learned friend made. Happy to be dealt with and heard and for us to respond to them, but not in a case management conference. The point he made in that same submission was in relation to the incorporation of Standard Chartered Bank, whether it was in London or elsewhere, and the branch in the DIFC and its status with respect to the jurisdiction of court. For now, I'd say that accepting the jurisdiction of the DIFC court has nothing to do with applicable law. But that's all I'll say, and that will be obviously heard and dealt with in the summary judgment, immediate judgment application. And the reference to Corinth is misconceived, because Corinth is about the DIFC court's jurisdiction, not regulatory law as applicable on shore. The sixth point was the same in relation to contracting out of DIFC law. Again, it's a point we'd be happy to debate in this immediate judgment application, but not now. A seventh point is about, again, I think my learned friend was talking about a cut-off date for applying for immediate judgment being 23rd of January, which is 7 days before the hearing. I made the point in my first time on my feet, which was that there is no deadline for bringing an immediate judgment application. If it was brought a month ago, perhaps we could have had a hearing today about it, but it wasn't, and there was no reason for it to have been done that way. Points 8 and 9 I won't deal with because I think they just covered some of the other points, but sought to amplify them. And point 10 with respect to the amendments, I've already discussed. So in short for that, we'd be accepting their amendments provided we can put in a defence and provided that the costs of amending the defence are borne by the claimant. Thank you.
With your permission, Your Honour, may I respond to some of the key points very briefly?
Very briefly, please.
Your Honour, my learned friend raised, he said that my question was whether you agree to the amendment application that we have moved, because if they agree, then there is nothing for me to argue before this honourable court. The matter comes to rest. They said in their submission that we agree, we don't like the form and the manner in which it was presented. Nevertheless, we are willing to concede those amendments, as long as we also are given our right to amend our defence, and claimant should bear the cost for bringing up its part of the amendment and for our part of the amendment. Now, Your Honour, this is exactly the summary of what was submitted in this review point. And the second point my learned counsel also brought to the attention of the court is that the claimant seems to argue that this honourable court should not, that it has no right to bring, that defendant has no right to bring an application for immediate judgment. And this was the second point. My answer to both these questions, Your Honour, is very simple. Until he made this submission before the honourable court, until I came in front of the court and this submission was made before this honourable court, I actually did not even think about this aspect that they have no right. But now that my learned friend has made a very important admission that changes the case altogether. The admission that he has made is, he says that I concede that I agree to your amendment subject to these small qualifications. While I don't agree to that, but once, the point here is this, once the defendant concedes that it has no objections to the amendment, to the statement of case, then no immediate judgment is possible. I will explain this point. The rationale for this argument is that if based on defendant's concession, after all, Your Honour, it's a concession that they agree, or it's an agreement. If based on their agreement or based on their concession, amendment is allowed by this court. If they make the submission, this court in its case management order will make an order. Once it makes an order that this amendment is allowed, there are two things that will happen. First, issues will have to be framed. When you say, I admit the trial must start, then issues will have to be framed. And second, the questions that have been raised through the amendment, means the violation of the questions of law, will have to be adjudicated upon on its merits. Now, these are the two essential prerequisites. The legal effect of this concession by the defendant is that such concession rules out the remedy of an immediate judgment. Once issues of law and fact are raised, then court is bound to adjudicate the case on its merits, and claimant has a legal right to prove its claim. Procedure cannot be scuttled. There is a strange contradiction, Your Honor, in the submission. The contradiction is, on one hand, they agree to the amendments proposed by us to the statement of case, means they agree to the issues to be framed. I'm not saying they agree to the issues as we have framed, but they agree to the issues to be framed, because it's the logical conclusion of it. When you say, I agree to these amendments subject to these qualifications, you agree to the issues being framed, you agree that the questions that have been raised must be decided and must be heard on its merits. If this is your submission before this honorable court, how can you in the same breath argue before this court that there is no case, a case cannot be heard on its merits, and there is no reasonable prospect of success, which means you don't want the case to be heard on its merits. That's why you move this application. Isn't this a strange contradiction? Now, having said that, at this stage of the proceeding, my learned counsel must inform the court whether it still concedes those amendments that we have made in our application. It's willing to concede those amendments, number one. And if it is willing to concede, then by operation of law, by implication of law, by analogy, he cannot in the same breath argue that I want to move an application for amendment judgment. In which case, my learned friend will have to tell his honorable court, in view of this submission, I will now withdraw the application. But he cannot say that this case should proceed on the merits by accepting the amendment and then say the case has no substance. Your Honor, this is an extremely important submission on which a ruling must come, a finding must come, because this is a contradictory stand taken by the other party. Your Honor, my learned friend also raised, when he was going through my 10 points, you must have noticed, Your Honor, my learned friend told the court that out of these 10 issues, he gave the points. He said these issues will more appropriately be dealt with. And he said it very rightly. In the application, when the application is heard, I don't dispute that. I agree with him on the submission. But let's look at the effect of what he said, Your Honor. The effect of what he said is that all points to be discussed when immediate judgment application is dismissed, which means there are points, which means there are issues, which means there is no clear point on which he can say that defendant does not have, claimant does not have reasonable prospect of success. At least this is the logical outcome of what they have stated. And Your Honor, my point is very simple. I want to conclude my first part of this, unless there are other issues. I want to bring only two important submissions before this honorable court. First, Your Honor, case management conference is not about discussing the immediate judgment. The only reason I raised those submissions before the court and gave those 10 reasons was because they said it will be a waste of the time of the court at this stage to look into those reasons, to look into the case management conference, to agree to a timetable. We don't want a draft timetable, Your Honor. We want a timetable for how the trial will proceed. And we want that timetable to be recorded into writing, and then we want a progress of that timetable to follow. If they succeed in their immediate judgment application, which is before the court, Your Honor, automatically the presiding judge will also look into the effect on all other theory, and then this particular timetable framed by this court will automatically be amended. So it's not a waste of time, because there is no guarantee, Your Honor. If there is a guarantee that they are going to succeed in their immediate judgment, I'm willing to concede that discussing this case management conference normally on all issues should not be looked into. But if there is no guarantee, then I am not willing to concede this argument. However, Your Honor, being a lawyer, I have a duty to bring to the attention of this court two small clarifications in our document that we have submitted, which may have gone unnoticed. But as a lawyer, it is my duty to bring those to the attention of the court. I draw the attention of this honorable court to tab 1, case management information sheet. Page 3. Your Honor, with your permission, the question at 11A, I want to clarify what we have answered. 11A and 11C. In 11A, it stated, on the evidence of how many witnesses of fact do you intend to rely on at trial, subject to the directions of the court, please give their names. Your Honorable Court may note that Mr. Vejit Ideas and Ms. Mighty Gunar are our two witnesses of fact. And the names and what the claimant intended here is that the three other witnesses are the witnesses of the defendant, who the claimant wants to summon today through this case management conference, seek an order that they should submit their testimony since they are essential witnesses. So it should not be understood by this honorable court, since we did not clarify here, as if all five of them are our witnesses. So this is the first thing I wanted clarification. I wanted to provide to this honorable court. And Your Honor, the second clarification, which again is important, is in 11C. In 11C, it is written, how many of these witnesses of fact do you intend to call to give oral evidence? Inadvertently, Your Honor, it is stated here that we do not intend to call the witnesses to give oral evidence. Your Honor, because witnesses, their testimony is evidence in chief. So naturally, there's a right of cross-examination by the other party. So this was, inadvertently, we made this error in our thing, and we seek the leave of the court either to amend it, or the court may, under its case management powers, write it as we have explained, or record it as we have noted. So these are the only two things I wanted to bring to the attention of the court. What is breach? Yes, and there is point number 15, Your Honor, on the next page.
But for this point, you want them to attend the trial?
Yes, Your Honor, we want them to attend because we want them to, we want to cross-examine them. They are essential witnesses to this case. And Your Honor, just a small administrative point number 15. Is this case in which a pre-trial review is likely to be useful? We have written no. Your Honor, of course, pre-trial review is useful. These are the 3 points I wanted to bring to the attention of the court. Your Honor.
In regards to an application for amendment, both parties agree on the amendment, which from what I heard from both parties, both agree. The claimant will amend their statement of claim, and the defendant will have the opportunity to respond or to amend their claim as a response of the claimant's amendment. And for the second application, which is the immediate judgment application, to me it is more reasonable to set a timetable for an immediate judgment application at the CMC, and once the court decides the application, then we can discuss the timetable of if the defendant was unsuccessful with the immediate judgment, then we can discuss the timetable towards the trial. If the defendant was successful, then the claimant will have opportunities pursuant to the RDC. So today we won't discuss the costs of the first application, which is the amendment. We'll leave it as costs in the case. And for the timetable of immediate judgment, I believe it should take the normal course of Part 23 habeas application. So starting from today, if this will be considered as service, starting from today, the timetable will be pursuant to the Part 23 heavy application timetable. Then the registry will liaise with both parties in listing a hearing pursuant to their availability and the judge's availability. Yeah?
Thank you.
One submission, Your Honor. Sorry, I forgot to address the issue of costs. Your Honor, since you have said costs will be costs in the case, and since we have an opportunity to discuss this issue, we can discuss this at the time when the costs are being discussed. However, there is one, since a question was raised by the other party with regard to the costs, I only want to make one small clarification. Your Honor, from 13th January onwards, they have been writing to us and we have been responding and writing clarificatory letters which are there in our amendments. In fact, I have one objection to one of the small things. There is no question of an amendment to the statement of case because there is no such amendment. There is no addition. We have made 2 points very clear. My learned friend said that I have added new claims. I have added. There is one point I want to make. Relief clause in a submission is not part of part of the amendment. It cannot be considered as such. It is independent. It's not part of the cause of action. And merely pointing out that this, based on existing facts, we did not introduce any new fact. Merely pointing out that based on existing facts, certain additional provisions of the FZCO have been violated is merely assisting the court. Now, if you give them a right to respond to those 3 points that we have raised, and their response should be specific to the violations that we have proposed. If we have said Article 40 of the DIC contract law has been violated, there I want this Honourable Court to make the order specific and say that they must respond specifically to that objection. They should not be given the right to amend their statement of defence because I have not amended my statement of case. If I amend my statement of case and introduce new facts, new issues, I have raised pure questions of law. Pure questions of law can be raised even in the skeleton, even when I write my skeleton argument, Your Honour. Even at that time, I can introduce pure questions of law for consideration by the court. In the interest of helping the other party to move and this process to move in a fair manner, we brought those amendments at an early stage. Now, costs cannot be definitely paid by us because they delayed the whole proceedings, but that's a separate issue. Your Honour has said costs will be costs in the case, so we'll discuss that at a different stage. But at this stage, Your Honour, the order must be very specific. They should not be given. I humbly, as claimant, I object to them being given the right to amend their statement of defence because I did not amend my statement of case. I only brought out the violations. And the only way, Your Honour, I could break the violations is through the procedure known as amendment. So the court has to see whether I have introduced new facts. Court has to see whether I have introduced new causes of action. Court has to look into those facts. If I have not done so, their reply, the Honour must note in the reply, that reply must be specific to what I have raised. They should not introduce any new thing in the amendment to the statement of case. It should be rather a reply to what we have stated. So this is the only submission I want to make.
Two very brief points, if you may. As for one point that my learned friend made earlier was about ordering compulsion of witnesses. I note that Your Honour did not raise that as a consideration in the CMC, and I respectfully agree that's the right approach. Compulsion of witnesses is under a very specific regime in the rule book, Part 30, which talks about compulsion of witnesses. So if the claimants seek to have witnesses from the defendants attend or submit witness statements or in any way examined, there is a process for that. It's not appropriate for an ad hoc request of the CMC. In relation to the amendment, whilst we accept that the job of the defendant is to respond to the new parts of the particulars of claim, I don't think it's necessary to specify that and restrict the defendant in any way, whether intentionally or not, in the order. We are obliged to follow the rules, and the rules prescribe how to respond to an amended particulars of claim, which we will do. That is to say, the amended particulars that are marked up in track changes to show what's new, those will be responded to. The only issue I'd like to say is that in the reply document, our submission is still that that was not a reply in the traditional sense. Replies respond to the points made in defence. The reply was very different from that. It was an amplification of a whole bunch of points that the claimant had made, but in addition to that, it was raising additional laws, causes of action, and claims, which we reserve our position as to what to do with. It might be that we apply to submit a rejoinder to that reply. But as so far as responding to the amended particulars, I'm in agreement with my learned friend. I just don't think it should be in an order. Thank you.
Because we will move with the timetable of the immediate the heavy application, which is the immediate judgment. When will, and I believe the amendments are required in the hearing for the immediate judgment, when will the amendments be ready?
The amendments to the particulars of claim are already in on the record. The defendant does not need to file amended defence in order for the immediate judgment application to take place. We have enough on the record to be able to bring the summary judgment, the immediate judgment application, for it to be heard. The point would make that if the immediate judgment application fails, that's the point at which we've given time to amend the defence so that the case can carry on. The point on that is that whilst we may respond to the amended particulars, it might be all irrelevant because our immediate judgment application, I'm sure you haven't had time to look at it, is based on some very broad principal points, and the amended particulars make no difference to those points. Thank you.
Your Honour, if they do not succeed in their application for immediate judgment, which of course the cost will be considered, but the point to be noted is that taking away the case, stopping the proceedings also incurs costs, which I want to bring to the attention of this Honourable Court. Your Honour, this may be an ad hoc proceeding, but at the same time, the issue of, we want to know from them, because this is one of the issues written in our case management form, is I know the procedure is contained in Part 30 with how to summon a witness and all that, but that procedure will only have to be followed if they don't agree to bring those witnesses. Of course, in this application today, my learned friend can tell the court whether they agree to bring those witnesses or not. Because if they don't, Your Honour, then I should know that if I need to bring in an application in that regard, or I will request the court to pass an order if it can, under its powers, do so, or I will do an application for this, but I have a right to know whether the names of the three witnesses, which are their witnesses, they're willing to submit their testimony before the court.
I'd be happy to engage my learned friend in that discussion. I just can't do that right now because I don't have instructions, and we need to consider it whether those three individuals are even available. Certainly one is, because we've suggested that that person, Mr. Patamsi, will be putting forward a statement, but I can't commit to that at this stage. It would have to be happy to do it by phone call or correspondence. But if we refuse to put forward those witnesses, then it's my learned friend's job to bring the application. Thank you.
Your Honour, my only point is I can't be left lurking in the dark in absolute uncertainty, not knowing when they will decide, because under the rules we've notified that 7 days in advance that these are the three witnesses which we intend that whose testimony you must submit to the court, and we requested them through this application. I'm sure they had opportunity and enough opportunity to seek instructions from the client. Any attempt to say that we will seek further instructions from the client, then they should give right now before this court. I'm happy to do that, as long as they can tell the court if within a period of 3 days or 4 days they can inform the court whether they are able to obtain their testimony. There should be a time within which they must respond. This court must fix a time period for them to respond to that request, Your Honor. So that, because my only right then is to move an application. I don't want to delay the proceedings. I will then move an application requesting the court to direct them to summon those two people as witnesses. They are essential key witnesses in this case. We have dealt with them. Our case is incomplete without their testimony.
I've taken instructions, and we can confirm within 3 days whether those witnesses will be put forward by the defendant. So that's fine. The only thing I'd say to that is if my learned friend is in a rush to bring the application for these witnesses, then our submission is that that's not relevant for the immediate judgment, so he might want to save his client's money by not bringing that application until the immediate judgment is dealt with. Thank you.
And 3 days for them to respond.
Yes, sir.
Anything else you'd like to raise?
Your Honor, just the timetable, if you could fix, if this Honourable Court can fix a timetable for taking into account the impact, because if we should, assuming that we submit our reply to the immediate judgment, then within how many days will the case be listed for hearing?
This we'll have to check with the registry,
Mhm.
but it will take the course of heavy partner heavy application.
Correct. The court rules prescribe a heavy application timetable, so hopefully we can agree on that and submit it to the court for execution.
Okay. Thank you very much.
All rise.
Sorry,
It's done.
I will carry on.